Today we'll be discussing the strategy of when to file a provisional or a non-provisional patent application. The rationale will surprise you because it is not based on the cost difference between a provisional and non-provisional patent application, but on the acceptable spend rate and whether you would like to get your patent sooner or later. My name is James Yang. I'm a patent attorney. I've been helping clients get patents since 2004. If you like this video, please subscribe to my channel. One of the most frequently asked questions from new inventors and those starting out in the patent process is, should I file a provisional or non-provisional patent application? They think that a provisional application is cheap and a non-provisional application is expensive. However, this would be incorrect. The cheap provisional patent application won't give you the coverage that you need in terms of patent pendency. If you want the provisional patent application to give you sufficient protection, much more effort would have to be put into it, which would make the provisional patent application just as expensive as a non-provisional patent application. Let me explain. When you file a patent application, regardless of whether it is a provisional or non-provisional application, you are trying to establish a priority date. In this way, a third party couldn't come in later on after seeing your invention, file a patent application, and get a patent on your invention. Your first filed patent application would have priority over the later filed patent application. But priority is granted only for those aspects of your invention that are explained in the patent application. So, if you fail to include some aspect of the invention, you don't have priority for that aspect or feature. These are gaps in your patent application. If these gaps are filled by the later filed patent application, then the third party could get a patent. Many people think that they can just submit a brief provisional patent application, then 1 year later, if marketing goes well, file a non-provisional patent application. This is true except that the brief patent application most likely will contain gaps and jeopardize your ability to get a patent in those areas. Why would it most likely contain gaps? With a lower cost, the patent attorney has less time to develop the patent application. If you want to reduce the chances that the provisional application will not contain gaps in coverage, then the patent attorney needs more time and more money to work on the patent application. This is why the cost difference between the provisional and non-provisional application isn't significant if they were to give you the same level of what I call patent pendency type patent protection. The bottom line is that if the provisional application were to give you the patent pendency type protection to the same extent as a non-provisional application, the provisional application couldn't be brief. It would have to be just as thorough as a more expensive non-provisional application. I like to compare the cost of an application to a car. You can buy a car for $3 million or you can buy a car for $100. Both are cars, but perform very differently. The same is true for a cheap provisional patent application and an expensive non-provisional application. They are both patent applications, but they perform very differently. You might be asking yourself, then why do some patent attorneys advertise cheap provisional patent applications if they have a likelihood of being defective? My guess would be to get the client, you, in the door. It might also be that they don't have enough work. If you file a low-cost provisional application, you need to accept the risk that it includes gaps in coverage and that others could get a patent in those areas. Hopefully, through this discussion, you can begin to understand that when you file a low-cost provisional patent application, you open yourself up to risk. In my opinion, when you invest your time and energy into a business, the patent-related costs, say $10,000 versus $3,000, is not a big difference when you consider that all your time and energy could go to waste if you skimp on the initial protection that you're trying to get. Am I saying that expensive patent applications are well prepared compared to cheaper patent applications? No. Am I saying that expensive patent applications will fully, 100% cover you? No. No one can guarantee it. All I'm saying is that given more time, a patent attorney will be able to better prepare the patent application compared to one where they had a limited number of hours. If you are spending a lot of time and energy on launching your product or invention, then why expose yourself to the risk that you may have left a crucial detail out of your patent application? So, if the cost difference between the provisional and non-provisional is not the primary deciding factor as to whether you should file a provisional patent application or a non-provisional patent application, then the natural next question would be, what are the deciding factors? The deciding factors are 1, the spend rate, and 2, the timing of the grant of the patent. Do you want to delay examination expenses to conserve cash? If so, you would also have to delay the patent grant. On the other hand, do you want to expedite the patent grant to use the patent against your competitors or license your invention? If so, you would also have to incur patent-related expenses sooner than later. Let's explore. There are 2 big cost centers when you go through the patent process. The first big cost is the preparation and filing of a patent application. You have to incur this cost because it gives you your base patent pendency protection you need to market your invention. Typically, the cost to prepare and file a full-up patent application is about $8,000 to $15,000. The next big cost is the examination cost. After you file your patent application, the patent office eventually inspects it and lets you know whether they will grant you a patent or reject your application for patent. If it is a rejection, a patent attorney reads through the examiner's rationale and prepares a response trying to convince the examiner that your invention is worthy of a patent. The examination cost is about $2,000 to about $10,000. As a reminder, the 2 big costs are 1, the cost to prepare and file the patent application to establish patent pendency, and 2, the examination cost. If you want to slow down your spend rate to conserve cash, you have to delay the examination costs, but that would also delay the patent grant. You can delay the examination cost by filing the provisional patent application. It is never examined and it doesn't enter the queue for examination. This means that for at least 1 year or 12 months, the provisional patent application remains pending. No examination costs will be incurred. When you file the non-provisional patent application, your patent application will enter the queue for examination and will be examined on average in about 18 months. This means that you can spread apart the cost to prepare and file the patent application and the examination cost by about 30 months total, 12 months plus 18 months. On the other hand, if you want to get your patent sooner than later, then you need to file the non-provisional application to get your patent application into the queue for examination. You will wait about 18 months until the patent office examines your patent application and let you know whether they're going to grant you a patent. If you want to expedite the examination, you can file a Track 1 request or expedite request, which would give you examination of your patent application in about 6 months. The current system provides great flexibility so that you can get a patent fast, if desired, or slow down your spend rate. One strategy for using provisionals, non-provisionals, and expedite requests is to first file a provisional patent application. This is the minimum to get patent pendency for your invention. Start marketing your invention as soon as you get patent pendency. Depending on how the market is reacting to your product or invention, you can wait to file the non-provisional patent application for up to 1 year. If it is going well, then you can file well before the 1 year is up and also file the expedite request. If it is not going so well, then you can file the non-provisional closer to the 1 year deadline with or without the expedite request. In my opinion, The cost difference between a provisional and non-provisional patent application shouldn't be the deciding factor as to which one you should file first. Rather, the deciding factors are 1, spend rate, and 2, the time to patent grant. If you're still unsure of whether to file a provisional or non-provisional application, a safe route is to file the provisional application first. Why? Because you can change your mind later on. You can file a non-provisional application the next day after filing the provisional patent application. However, if you file a non-provisional application first, it will enter the queue for examination and you will incur examination costs about 18 months later. You can't undo the filing and ask the patent office to consider your non-provisional filing like a provisional filing. I hope that this helps you to understand provisional and non-provisional applications better and how you can use them to your advantage when you are launching your product or invention. Thank you.